streamed on the court's YouTube channel, in all of which is to comply with Texas Supreme Court orders and rules and directives from the Office of Court Administration. Since these matters are being presented, or these hearings are being conducted in this fashion, it also results in the court issuing an order prohibiting any person, whether participating in the Zoom hearing or watching on the court's YouTube channel, you are prohibited from making any recording of this proceeding in any fashion, except the official court reporter is authorized to make such recordings, which he does and is doing, just like he would do if we were in open court in person. With those announcements and pronouncements, I call upon the state for purposes of these plea hearings. What says the state?
State's ready, Your Honor.
And the defense.
Defense is ready. I'm the defense. All right. We're the defense. The defense is ready, Your Honor. One note, do you want me to send that directly back to Kayla, or do you want me to go ahead and send it down to Jera? Either one.
Either one is fine, but I would suggest you send it directly to Ms. Phipps.
I will send it to her, and I'm scanning it now. So with that pronouncement, defense is ready.
All right. Mr. Teeler, are you Michael Ray Teeler?
Yes, sir.
Mr. Teeler, indictments have been returned in these two cases that I have called. You have the right to have the indictments read out loud to you in each of these cases or in either one of the cases. Do you wish to have someone read the indictments out loud to you?
No, sir.
Do you understand that in 10,848, the charge is unlawful possession of a firearm by felon, and in 10,849, the charge is a state jail felony charge of theft?
Yes, sir.
Then, understanding the charges, let me ask you, to the charge of unlawful possession of a firearm by felon, how do you wish to plead, guilty or not guilty?
Guilty.
And to the offense of state jail felony theft and cause number 10,849, how do you wish to plead to that charge, guilty or not guilty?
Guilty.
And do you understand that you do not have to enter a plea of guilty to either one of these charges? You have the absolute right to enter a plea of not guilty, and further, to not have it held against you just because you might exercise your right. Do you understand that?
Yes, sir.
You also have the right to have a minimum of 10 days notice of the charges against you in each case. I've looked at the court's files, and the docket sheets indicate you have had more than 10 days notice of each charge. Nevertheless, I would grant you some additional time if it was needed.
Yes.
You also have the right to have a jury hear your case. And that's true even if you plead guilty to the charges, as you've indicated you wish to do. Do you understand you have the right to a jury trial?
Yes, sir.
I have been handed documents entitled waiver of defendant. Each one in each case says you're giving up the opportunity to have more time, and you're giving up the right to a jury trial in each case. Did you know that's what you were doing when you signed those papers?
Yes, sir.
Mr. Darnall, your signature is on each document as well. Are you joining your client in these waivers?
I do so join, Your Honor.
And Mr. Smith, your signature is on each of those waivers as well. Is that indicating the state is joining in the waiver of the right to a jury trial?
Yes, Your Honor.
I accept the waivers in each case. And Mr. Teeler, let me discuss some other matters with you that I'm required by law to discuss. Let me start by talking about the range of penalties for these charges. In the state jail felony case 10,849, the range of penalties runs from 180 days up to 2 years in state jail, and it carries the possibility of a fine being in an amount not to exceed $10,000. In cause number 10,848, the third degree felony charge for unlawful possession of a firearm, the range of penalties runs from not less than 2 years to not more than 10 years in the Texas Department of Criminal Justice, the institutional division. And it also carries the possibility that a fine could be imposed, and if so, in an amount not to exceed $10,000. Do you understand that's the possible range of penalty that exists in each one of these two cases?
Yes, sir.
Then let's go for a little bit, let's go further.
Your
Let
Honor,
me tell you, yes.
each of those indictments contains enhancement paragraphs. I thought I should draw your attention to.
Thank you.
Or Mr. Ernie,
Yes, sir.
in one of them indictments, I did read, it said Missouri County. I was in state jail at that time. I
Yes,
don't
sir.
see how I got a gun charge.
I understand, but you need to listen to your attorney, what he said to you.
Oh, okay.
Let me also tell you that there are two enhancement paragraphs alleged in the cause number 10,849, which would enhance or increase the possible punishment to that state jail felony up to a third-degree felony, which carries the range of penalty as I've outlined for a third-degree felony. And in cause number 10,848, the unlawful possession of a firearm charge, there is an enhancement paragraph which, if proven true, could enhance or increase the punishment range up to that of a second-degree felony, which is not less than 2 years nor more than 20 years in the Texas Department of Criminal Justice. Do you understand those are the possible ranges of punishment that exist in these cases?
Yes, sir.
Now, I started to say, and so I will pick up there, that I am aware that plea agreements exist in each of these cases. Under the law, I do not have to follow those plea agreements, but I have to tell you if I'm going to follow them, because if I don't follow your plea agreements, the law says you can take back your pleas. And if so, we just start all over so that it won't be used against you for entering any kind of a plea.
Yes, sir.
But if I do follow your plea agreements, then the law says you will be bound by the terms of the plea agreements, and you can't get out of the terms of the plea agreement, and you can't change the terms of the plea agreement if I follow it. And one of the terms of the plea agreement in each case says you're giving up the right to appeal. Ordinarily, there is a right to appeal, but since it's in the plea agreement that you're giving up the right to appeal as a part of the plea agreement, that provision means what it says also. And so if I follow your plea agreements, then that means you cannot appeal at all. Do you understand that?
Yes, sir.
All right, so then let's go a little bit further in this plea discussion. And let me ask you another question or two that I'm required by law to ask. First, are you a citizen of the United States of America?
Yes, sir.
Where were you born?
Snyder, Texas.
Next, I ask, do you consider yourself presently, that is at this time, to be mentally competent?
Yes, sir.
You know what? Do you know what's going on in these proceedings?
Yes, sir.
Have you been able to talk to your lawyer and cooperate with your lawyer in getting ready to meet these or to have these matters heard, as well as to listen to his advice, hear his advice, and understand his advice about how the law affects these cases? Have you been able to do those things?
Yes, sir.
Mr. Darnall, do you believe your client is mentally competent?
I do so believe, Your Honor.
And I accept that representation. I have met with Mr. Teeler in times before and observed him here in our Zoom hearing. I too believe he is mentally competent, and I make those findings in each case. Mr. Teeler, my next question asks, are you satisfied with the legal representation your attorney has provided to you in these matters?
Yes, sir.
Thank you.
And let me tell you why I asked that question, because I'm not trying to suggest that you wouldn't be or shouldn't be. Instead, I just asked that question so you'd have a chance to tell me if you were not satisfied. Because by giving you the chance to let me know now if there's a problem so I can get it fixed, that necessarily means you're not likely to be successful if you wait to some later date to say your lawyer didn't do a good job. In other words, now's the time to tell me that if you thought that was the situation. Do you understand that?
Yes, sir.
And understanding that, are you still telling me you're satisfied with your lawyer's work in your behalf in these matters?
Yes, sir, I am satisfied with it.
All right. Then one other area of inquiry, this one having to do with your decision to enter these pleas of guilty. I need to be satisfied that these are your decisions of your own free and voluntary will. And so I ask you, has anybody threatened you or forced you or tricked you or in any way tried to make you plead guilty to these charges when you would not otherwise do so?
No, sir.
Has anybody promised to give you something of value, anything, money or otherwise, just to get you to plead guilty to these charges when you would not otherwise do so?
No, sir.
Then are you telling me that you're pleading guilty to these charges because the truth is you are guilty of these charges, and that's the only reason you would plead guilty to such a charge?
Yes, sir.
Those are all the questions I have at this moment. Mr. Smith, you may proceed.
Your Honor, in each case, the state offers for evidence a document marked as State's Exhibit 1, each of those being this defendant's signed and sworn stipulation in its respective case.
No objection, Your Honor.
Mr. Teeler, let me talk to you about these stipulations then. And in doing so, I'll mention some other rights that belong to you and some that fit right here. For instance, I'll tell you that the state is required to produce some evidence tending to show your guilt, even though you're pleading guilty. And that's a part of our law because it helps to ensure that another right that belongs to you is in fact provided to you. And that is your right to see and hear the witnesses who might testify against you. We call that the right to confront the witnesses. But the stipulations of evidence say you're giving up the right to confront the witnesses and telling the state they don't have to bring their witnesses into court at all. Did you realize you were giving up those rights, the right to see and hear the witnesses testify when you signed these stipulations?
Yes, sir.
The stipulations also say you're giving up your right to remain silent in each case and your right to be free from self-incrimination, which is the right to not be forced to give evidence against yourself. And instead, by signing the stipulations, you are giving evidence against yourself and thus providing the state with the evidence I said they have to furnish, because the stipulations are judicial confessions where you admit the commission of the offense, just like it is alleged in the indictment in each case. Did you realize you were doing that when you signed the stipulations?
Yes, sir.
And each stipulation also has paragraphs talking about your prior convictions that were alleged in those indictments. And the stipulations say that you are admitting that those prior convictions are true. Did you know that that was in the stipulation?
Yes, sir.
And are you admitting that those prior convictions are true?
Yes, sir.
All right, State's Exhibit 1, the signed sworn stipulation of evidence is received as evidence in each cause. Now, let me also say that for the record, that in cause number 10,849, the signature pages of the stipulation in that case consist of 2 pages, one that has the notary's notarization of Mr. Teeler's signature, and the second one does not have that, but has the attorney's signature. Is that your understanding, Mr. Darnall?
That is, Your Honor.
All right. Now I'm going to sign both just to evidence my acceptance of same. With that, Mr. Smith, you may proceed.
Judge, the state rests.
Defense rests as well, Your Honor.
State closes.
Defense closes as well.
All right, Mr. Teeler, I announce that I will accept and follow your plea bargain agreements in these cases. So let me go over them with you just to make sure you and I understand them the same way. It appears to me that the plea agreements are identical with one exception, or they appear to be the same with one difference. Each plea agreement says that you will enter a plea of guilty. Each plea agreement says, as a result, you will be sentenced to the Texas Department of Criminal Justice. Each plea agreement says you will pay court or be ordered to pay court costs in the sum of $290 and reimbursement fees in the sum of $675. Each plea agreement says you will waive the right to appeal, and each plea agreement says you will be given back time credits of 132 days in each case. And then the difference is the plea agreement in 10,849 says your sentence will be for a period of 5 years. And in cause number 10,848, your plea agreement says the sentence will be for 10 years. Now, there's one other unwritten provision that, since it's not in writing, the law says that these two sentences will run together, that is, at the same time, and they will not be stacked. That's my understanding of the plea agreements in these two cases. Is that your understanding of the plea agreements in these two cases? Mr. Teeler?
Yes, sir.
All right, sir. Mr. Darnall, have I stated the plea agreements accurately as you understand them to exist?
You have, Your Honor.
And Mr. Smith, have I stated the plea agreements accurately as you understand them to exist?
Yes, Your Honor.
Then let's proceed towards finishing these matters this afternoon. And I announce in cause number 10,848 and 10,849, each case being styled the state of Texas versus Michael Ray Teeler, that based upon the evidence stipulated to in each case and based upon Mr. Teeler's plea of guilty in each case, I find that Mr. Teeler is guilty in each respective case of the charge alleged in the indictment in each respective case. Those pronouncements being made, Mr. Teeler, do you know of any legal reason why a sentence should not be pronounced at this time?
No.
Then, in cause number 10,848, I hereby sentence you to serve 10 years confinement in the Texas Department of Criminal Justice, the Institutional Division. I order you to pay court costs in the sum of $290 and reimbursement fees in the sum of $675. And I grant to you, as your plea agreement calls for, 132 days of time credit against that sentence. Also, in cause number 10,849, I sentence you to serve, as per your plea agreement, 5 years confinement in the Texas Department of Criminal Justice, ordering you to pay court costs in the sum of $290 and reimbursement fees totaling $675. And I also grant to you the time credits in that case of 132 days. And I announce that these two cases will run at the same time. We call that concurrent. They will not be stacked. They will run together at the same time. I note that your thumbprint has been placed on each of these judgments. And with that, we will be in recess. Mr. Teeler, I want to wish you success, and I hope and pray that everything will go well for you as you go forward in your life.
Yes, sir.
Thank you, sir. We're in recess. Now then, Mr. Darnall, if you can get me to be as quiet as Mr. Teeler was throughout those proceedings, you will be a very successful lawyer.
I will try to endeavor elsewhere.
All right. Well, thank you for working with us this afternoon. Do we have anything else?
Not with Sam.
Oh, phooey, I forgot. That takes care of everything we have with you today. Mr. Darnall, I look forward to seeing you again in person. Have a good weekend.
You all have a good weekend as well. It's good to see y'all, even if it's by Zoom.
Yes, sir.
Hey, Sam. See ya.
All right.
Again, thank you, sir. Let's do that Plunkett
Sure.
arraignment.
Did we ever hear anything else on that Vieira defendant that Connie said she was bonding? I think
I
she.
haven't. The
I
answer,
haven't either.
I
That
have.
was
okay, there we go. The one who knows everything.
She was released and supposedly she's going to be retaining Mr. Green.
Is she planning on submitting to an arraignment at some point?
We're going to schedule one and require her to be here.
All right.
And we'll do so next week during a time that we might have other things scheduled with you.
Okay.
If that will fit your calendar.
Oh, I'll be here all week. No problem.
Okay.
I just wanted to make sure we didn't need to be getting a nice eye out there for him.
Yes. I appreciate it. At least not yet. And I hope we don't have to.
Okay.
I call cause number 10,860 for the case style, the state of Texas versus Crystal Ann Plunkett. This case is called for purposes of arraignment. Are you Crystal Ann Plunkett?
Yes, sir.
Ms. Plunkett, you are in the law enforcement center, and in that, what we call the Zoom kiosk room, you may remove your face covering. And if need be, you can take a deep breath. Ms. Plunkett, an indictment. Oh, let me announce that this hearing is also being conducted by remote video teleconferencing technology using the Zoom protocol. And it is being live streamed on the court's YouTube channel in order to comply with Texas Supreme Court orders and rules and directives issued by the Office of Court Administration. Since it is being accomplished in this fashion, I would also advise that all persons who might be able to see this hearing are expressly prohibited from recording the hearing or any portion of it by any means, whether by Zoom, YouTube, or any other photographic or electronic means. With that said, Ms. Plunkett, let's discuss your arraignment. You have the right. No, let me ask you first. Ms. Plunkett, are you out on bond?
Yes, I do so. Am I on? Yes.
When we finish this, will you be able to walk out of the law enforcement center and not be held by anybody for any reason?
No, I'll be able to, yes.
I do not know. When did you get a copy of your indictment?
Just a few minutes ago, really.
All right. So you've just now been served with that. Have you talked to your bondsman today?
Actually, she's supposed to come back in 2 hours. She brought me up here.
So the answer is yes, you have talked to her.
Yes.
All right. And she plans to substitute her bond after you are processed on this, in this arraignment. Is that your understanding?
Yes, sir.
All right. Since you just got a copy of your indictment and you're not yet out on bond, although you plan to be very shortly, I need to tell you that you have the right to have 2 days notice of the charges in the indictment. You just received it, so you haven't had 2 days notice. And so we can reschedule your arraignment and have you come back again after 2 days, or you can give up that 2 days notice and instead proceed with the arraignment this afternoon. What do you want to do?
Hopefully Thursday.
I can tell you.
If I take the 2 days.
See if I explain it to you where I can't explain it.
Okay, if I take the 2 days one, that means I get to go home and then come back?
You get to go home whether you take 2 days or not.
Okay, but if I do it this evening, then I just stay here?
No, if you do it this evening, from what you've told me, your bondsman is going to come bond you out and you will be released. And you will have to then come back to court as we set your case for trial. The arraignment does not keep you in jail. It just discusses what the charges are and how you want to make sure you know what they are, things of that nature.
Let me do the 2 days. I think that would be better.
All right. Then you will have to come back when I schedule it. And let me tell you, when I schedule it, you cannot say, I can't be there. When I schedule it, you will have to be here. If you aren't here, we will issue an arrest warrant for you.
Yes, sir, I understand.
Okay. It is your absolute right to have the 2 days. I will grant that to you. We will reschedule your arraignment. We will do it probably sometime next week. And with that, subject to having your bond taken care of by your bondsman, you are in the custody of the sheriff, but as soon as your bondsman takes care of it, you will be released on bond.
So I'll still be here in jail?
Until your bondsman takes care of it with you, and then you will be released.
Okay.
You're in jail right now. You understand that? Is that a yes?
Yes, sir.
And you will stay in jail while they process you, it's what it's called, until your bondsman takes care of giving your bond to the sheriff's office and to the court system. And that may be 10 minutes, it may be 2 hours. I don't know how long it will take, but then you will be released today.
Okay. All right. I understand.
All right. With that, we're in recess. You may be excused.
Okay.
Is there anybody else, Judge? I believe that's it.
That's it. That's all I have. Thanks, Randy.
Thank you.
Thanks,
Have a
Randy.
good weekend. Thank you. Thank you, Ben. You too.
Yes, sir. Have a good one.
I'm gonna try.